Thank you so much for tuning into Chapman Law Group. This is our segment of health topics, and today we're going to talk about estate planning and probate. Governor Whitmer in Michigan, like many other governors, has issued an executive order that has some interesting twists and some interesting implications for estate planning and probate. Today with us, we have Dave Mammal, who is the practice chair of estate planning and probate for Chapman Law Group. Good afternoon, Dave.
Good afternoon, Ron. How you doing?
Why don't we start out with telling people a little bit about estate planning and probate. What is it? And then we'll get into some of the specific topics about Governor Whitmer and all of that type of thing.
Sure, and that's an important distinction to make right at the top here. Ron, about half of the population doesn't have an estate plan. Well, what is an estate plan? I should even characterize that by saying that about half of us have plans that we've actually made with wills, with powers of attorney, with trusts, and then the other half have a plan that they may not even know has been made for them by the state of Michigan. So if we pass away without a plan, we're going to deal with the state of Michigan's plan, and it may not be a plan that you like. Now, with a will, you can identify who receives your assets at the time that you pass away. It might be the house, it might be bank accounts, it might be investments, but essentially, who receives what you have. However, here's the problem with a will. With a will, it must go to probate court. With a trust, on the other hand, you can keep things out of probate court. With a will, if you go to probate court, you're going to be dealing with more expenses of administration. You're dealing maybe with judges' calls on certain issues. You're dealing with more expenses, but you at least have taken control, unlike about half of the population, with at least what is happening with your assets, who's receiving, and so forth. In a trust, it starts from the time period that you sign that trust, that you're managing and maintaining your assets through a entity that is a trust. It's on paper. You basically set your bank accounts, your house, your investments, right up into your trust. And then, of course, there are the powers of attorney. We'll talk about that in more detail as well. But these are the important documents that so many people are thinking about right now, because they wonder, what if I'm unable to make decisions for myself relating to healthcare issues? Who is going to take care of those things for me? Who will make those decisions that I trust in my terms, in my situation? Same thing with respect to financial powers of attorney. Who's going to handle those issues if I'm unable to, either physically or mentally unable to handle those things?
So a lot of people, when you think of estate planning, you think of trusts and probate, you think of old people. But do these things only relate to old people? I'm an old guy, I'm 63 years old. So does it only relate to me, or does it relate to maybe my children who are in their 30s?
It really relates to everyone, Ron. And let's go back for a moment to the powers of attorney. From the moment that our children or grandchildren or anyone who's 18 years old turns 18 years old, they're going to be in a situation where they will no longer have their parents being able to make decisions on their behalf. So up until the point where our children were little babies growing up in grade school, in high school, whatever it was, we were able to make decisions on their behalf to handle health issues. Suddenly, 18-year-old hits, 18th birthday hits, and at that point in time, we no longer have that ability to make those decisions. So what if our son, our daughter goes off to college or something like that? At that point in time, something happens, God forbid, that they end up in a traumatic accident. Without a court order, mom and dad cannot get into medical issues, discussions with the doctors because of HIPAA. The Health Insurance Portability and Accountability Act, which is a lot of syllables. In short, it's the Healthcare Privacy Act as we know it. And the bottom line on that is that if we basically have nothing in place for our children at age 18, then we're in a situation where we actually have to get a court order unless the doctors will move around that issue. With respect to once we get married, issues come up as well with children. If we pass away as, say, a 30-year-old, Ron, that you mentioned a moment ago, and we have children, they're going to be going through probate court according to the state's terms unless we have a proper plan in place.
So what I hear you saying, and it's something that maybe a lot of people don't think about, one of the reasons to have an estate plan is to protect who gets to make decisions for you, for your children, for your spouse, those types of things when anybody becomes incapacitated, or dies.
Absolutely. So many people forget about it. The fact that when they plan, they're not just planning about who receives their assets, they're also planning for themselves, for the security of knowing the right people are in place at the right time when they need it most.
So the one aspect is you're taking care of the people you love by who can make decisions and who can make decisions about your life. The other thing we talk about is assets. Can only rich people have trusts?
Absolutely not, Ron. In fact, so many of my clients wouldn't be called the quote unquote rich people, but they have trust. Why? Because they're organized, because they take control of the situation in front of them. That they know that in the event something happens to them, mental incapacity or death, they know that things will be handled by the people that they've identified. Now I'm talking about things being, again, their home, their cars, their assets, their insurance policies, their annuities, their investments, making sure, again, that those things are handled. And I can tell you that I've had, yes, your multimillionaires who have those trusts, but all the way down to average Joe and Sally Jones who might have, just your average means and average money.
So how do you start these conversations? Most young people, let's talk about the issue of having guardianship and being able to decide who, whether how your healthcare is going to be if you're incapacitated. How do you start those conversations? Most people, we think we're infallible. When I talk to my wife, she says, you're not going to die. So how do you get that conversation going, particularly when you're young? The 30, 35, 40-year-old, they're infallible. They don't want to think about these things. So how do you start that conversation?
How do you start that conversation? Always a question. It really depends upon each individual. But if you think about how much you love your spouse, love your children, and you want to provide for them, think about so many of us adults, husbands and wives are going out into the workplace every day. Why? Because they want to make things better for their children and stable for their children, provide security. Well, one of the ways that we can provide security is even if we're not here. And so having those conversations might happen at the dinner table. It might happen at the end of a day of work. It might happen with family out on vacation. I can tell you there are things that also prompt that decision, Ron. There are times when unfortunately we have loved ones who pass away and we see what happens to others because they didn't have a plan in place, or they didn't have the right plan in place, or they didn't update their plan. Each of these things happen. And as a result, we have a situation where there are so many different possibilities in which that can come up. Often, most often, should I say, you see it in a situation though where something happens to somebody else and they realize that, hey, that plan didn't work and I want to make sure that this problem doesn't happen to me.
Now, one of the things I've heard you say before in the office, just walking by, talking to clients, is an estate plan's not a one and done deal. What do you mean by that?
Not a one and done deal, because time changes, people change, issues come up, our relationships change, our desires for who we want to provide assets to change. And we should be looking at this on a yearly basis personally. And we should be talking with our attorneys anywhere between every 3 to 5 years as to what occurs in a situation like that. We're looking at things like births and deaths and marriages and divorces and other life-changing things that can occur that change who we're providing to, who will be those decision makers for us. And so we need to look at our beneficiaries on a regular basis. Are these individuals you want to provide to, in the amounts we want to provide to them, in the time periods we want to provide to them, at the right ages, and also to make sure with respect to our trusts themselves. We acquire new things over the years. We might acquire a bank account, an investment, real estate, and we need to make sure that those are properly funded into our trust. Funded means titling, or it means setting up a beneficiary, but we need to make sure that that happens. Now, Ron, if you don't mind, let me give you an example and a story of an individual who didn't do it exactly the way we should. Why? Because this individual did consider it to be a one and done deal. Now, there's a gentleman, this goes back probably about 20 years ago. when I was working as an attorney for a public administrator. Public administrators, and this one was in Macomb County, step into situations involving estate plans and in states when they're brought to probate court, when something goes wrong, when the wheels come off, when there are problems. Well, let me give you the background history of this individual. This is a gentleman who made millions of dollars on a nice little invention that he had. Everybody wanted it, and he obviously sold many of these inventions during the course of his lifetime. To protect his privacy and so forth, I'm not going to mention exactly what it was. But during his life, this gentleman got married. He prepared an estate plan that provided for his wife, but he also felt fondly for his brothers, his sisters. And so he made sure that he named them in the estate plan as well. Then he got divorced. Then after he got divorced, he got remarried, and then he died. Now, do you notice something missing there?
Sure.
Yeah, he failed to go ahead and update his estate plan after he got married and divorced the first time, so that when he passed away, he still had documents which provided to his original wife, to his, nothing to his current wife, and to his brothers and sisters. And so everybody became involved. Now, while many of us may argue that the original wife might have had a leg to stand on, it was enough to basically draw out things in probate court for the period of about, 2-3 years, in which there were many arguments, many hearings. A ton of money was lost on this, tens of thousands of dollars, so that the public administrator was brought in. And I then became involved with working things between the families, the brothers, the sisters, as well as I possibly could. Again, further court hearings occurred, and things got extremely nasty, both in court and out of court, between brothers and sisters and first spouse and second spouse and so forth. And at the end, when it came time to make the distribution, I provided the final checks at court. Why? Because I wanted to make sure that we had court security right there. And I can tell you that the tension was so thick that you could cut the air with a knife. It was one of those where basically everybody was extremely tense. Everybody was concerned and still bickering among each other, even as I was writing out the checks on behalf of the estates. But while at the court, one of the sisters of the man who passed away came up to me, and right next to her was her husband. Her husband had an oxygen tank that he was carrying or wheeling behind him. And this gentleman had been in the Korean War on a ship in the Pacific Ocean, and he had exposure to asbestos. He had asbestosis. And so the sister of the deceased man, the wife of the man with the tank, said to me, "David, we've just been through hell over the course of these past several years through my brother's estate. Look at my husband here. He has the oxygen tank. He's going to pass away sometime during the course of the next couple of years, based on what doctors are telling us. I don't want to go through that again." So I looked at her. I said, "Look, let's sit down. Let's make a plan. Let's make sure it's clear. Let's make sure it does exactly what you want it to do. And let's make sure you communicate with not only your husband, but your children as well." She told me, unfortunately, that her children fought a lot as well, and that was one of the reasons she was still concerned. But we did sit down. We did make that plan. Now, at that time, about 2 years later, her husband did pass away. But instead of going through probate court, she was able to go ahead and grieve her husband without all the additional stress, anxiety, arguments, and fights. A few years later, she passed away. And again, although her children fight a lot, this was not one of those issues they fought over. And why? Because she took control. She made sure that she updated her estate plan when things happened. She made sure that she didn't just let time go by. Because getting back to your point originally, it wasn't a one and done deal. She knew that things had to be taken care of on a regular basis to review things. And as things changed, we made changes for her. And and she avoided those problems.
Those are very good points. What I heard you say is anytime you have a major event, you should certainly look at your trust, whether that's a divorce, somebody dies, you inherit stepchildren, whatever the case might be. And every so many years, even if life hasn't changed, your property, your assets, relationships might have changed. So you should still come in and do a checkup.
That's right. That's right. All those things. And then also, they're the things that we generally, people in general in the public, don't know about. What happens if loss and so forth. Now, during the course of President Trump's administration, we've had 2 big laws pass. And in that context, we don't know unless we go back in to speak to our attorneys to find out what happened. And a couple of those that include the lifetime gift and estate tax exemption. It was back in the 1990s, $600,000. Now, back in about 2000, Congress said, we want to phase out what we call the death tax. Why? Because we're being taxed a second time, a double taxing. During the course of our lifetime, we pay income taxes each year. And then, after we pass away, we were getting taxed again, any amount over $600,000 to the tune of about 40–45%. So Congress, over the course of between 2000 all the way up to 2011, slowly began to phase out the tax. Well, they got to be a point where they said, wait a minute, let's put the brakes on and let's bring that tax amount up to about $5.5 million. That's a lot of money, and that takes care of 90–95% of the people out there. When President Trump took office, went a step further. And now, as it stands with the yearly increase, we're at $11.58 million that can go tax-free without anyone demanding the 40–45% from us. And that provides for basically just about 99.9% of us. I understand that Oprah Winfrey is still working on it, but beyond that, we're in a situation where the estate tax exemption has gotten much bigger. So if you look back at those plans from the 1990s, and I've had people come in, clients come in on every few months or so, who still had plans that were way back in the 1990s. Ron, you mentioned the one and done approach. Those individuals thought about it as being one and done, but they had plans that were set up for a much lower estate tax exemption, holding money in trust for a longer period of time, holding money in a position that their loved ones weren't going to be able to get to it as easily, even though the tax situation had changed greatly. Now, there is sort of the converse of that plan as well, called the Secure Act. And I'm not sure if you've heard of the Secure Act before, but the Secure Act came out on January 1st this year. Now, that essentially eliminated our ability to provide, during the course of a lifetime of our loved ones, a stretch out of our IRAs, of our 401ks, of our retirement accounts. And when it prevented us from being able to do that, it essentially said, we're going to move this down to 10 years. By moving it down to 10 years, Congress, our country, our government is getting its money from our IRAs that we had essentially stashed away, providing us with the ability to defer taxes and so forth, and they're getting their taxes further. And so that's caused a number of issues that require some updating as well.
We don't have a lot of time left, but what I hear you saying is laws change. Now, most people don't sit around reading probate and estate laws and things that affect that. Do you, if someone's your client, do you send them updates and say, hey, the law changed, maybe it's affecting your trust and they should come in?
Regularly, Ron. It's really important that, bottom line is I send out at least a yearly mailer to my clients to provide them with an understanding of new trends, new laws. And then when those laws like Secure Act and so forth come up, that's when something else is, I basically get in contact with those clients that I know have been trying to stretch out those IRAs, those retirement accounts for their loved ones.
And we don't have a lot of time left, so I'm going to ask you to, let's go quick through a couple things, but let's hit some definitions very quickly so people understand. What is a guardian for, what's a guardianship? Very quickly.
Guardian is care of the individual. That is at court. And essentially that's where the individual who may be a minor or may be mentally incapacitated has somebody taking care of their health and their custody.
What is You've used the word power of attorney, and I think you've even used the word the medical power of attorney. What's a power of attorney and what's a medical power of attorney, very quickly?
Sure. Medical power of attorney, again, are healthcare decisions. And that's much better, obviously, where we can take control of having our healthcare decisions decided by those we pick according to our terms rather than the guardianship at court. Power of attorney otherwise would be perhaps for financial purposes, and that's taking care of anything from our bank accounts to our taxes and things like that.
Now, when you go into a hospital for any type of procedure or anything, they make sure you have medical power of attorney. They may even hand you a form or ask you to sign some things. What's the cautions for that? Should an attorney or should a person who's going to have some major surgery or do some things, instead of letting the hospital suggest what they do, contact an attorney before they do that so they get these things in place?
Absolutely. Consider the stress that somebody might be undergoing at the time that they're about to undergo a major surgery, heart surgery, or some other surgery like that. And they're not necessarily thinking about each detail about what they want in place, how they want it in place. If you take the time, Ron, you can take the time with an attorney much earlier. That's where clients come to me and they say, hey, yes, let's take the time, let's figure out what we're going to do, what the terms are going to be, what people are going to take care of things, who those people are going to be, when they're going to take care of things, as opposed to just shortly before the procedure, maybe the day before the procedure, they quickly sign something off in a hospital.
Now, you used three terms. We talked about trustees, we talked about power of attorneys, we talked about guardianships, and you kind of defined them. My question here is, the individual is selecting some people. So a guardian is a person, a trustee is a person, somebody who has power of attorney to medical health or that's a person. How do you select that person? Do you just pick your best friend or your wife, or how do you do that?
And that's a great question, one which each one of us can make that decision for ourselves and have to make that decision. These are decision makers of all kinds. They're fiduciaries. These are people that we have an understanding on one hand, a long time track record. Do we feel that we can trust this person on a day-to-day basis? On the other hand, it's their own personal track record about financial acumen, people who are smart to be able to handle money, shown that they can handle responsibility involved with money, and to be able to make the decisions that we believe are right according to our value system and so forth. Those are the kind of things that I can tell you I've had seminars and discussions with groups that might have had a half hour of material, but I can tell you question after question, story after story came from those clients and those attendees of this seminars, and it probably went an hour and a half or more just because of how difficult that decision can be. But it's much better to take the time to make that decision rather than be rushed into that decision.
And if you don't have anybody in your life or your family that you trust in that way, are there professional trustees, professional people, like maybe an attorney, a bank, different kinds of things that you can do where you can put them in charge with specific rules to follow?
Absolutely. There are trust companies out there. There are companies that will provide for that. Yes, attorneys and clients have picked me in the past. There are CPAs. Those are also good individuals because they know the tax code. They know the issues that involve, what might have to be done with somebody's finances if it's a financial issue.
Now, here's the last area I want to cover. We're in the middle of COVID-19 and, this pandemic. Everybody's concerned, some people more than others, about death and other things. So I'm sitting at home. Governor Whitmer says I have to stay at home. I can't leave. And I'm like, I want to do this. So did she make provisions, the governor that is, were there provisions made so maybe I could do this from home and still get an estate plan and a trust and have it legal? Because I've heard you have to go to an office and have 3-4 witnesses, and it's a big to-do. Can I still do that from home if I'm stuck at home?
Ron, thankfully now we can do that. Governor Whitmer did pass basically issue an executive order in which she stated that she's temporarily suspending some of those formalities in terms of a individual being directly in front of the notary public in the notary public's presence while the individual notarizes the signer. The same thing with respect to witnesses. Governor Whitmer, I think, understood that, hey, we're dealing with a quarantine. we're dealing with social distancing, or we have a situation where we have 6 feet between us and so forth. She said, wait a minute. And this was based upon some prodding by the probate and estate planning bar in Michigan as well, where basically Governor Whitmer said, no, up through at least May 5th, and you know how things have been extended quite a bit, we're having a situation where we will have the remote signing. So how that's done is through this two-way communication. We're dealing with it through the context of Zoom or Skype or FaceTime or any of these other types of devices, so that so long as the signer and the witnesses and the notary public are able to witness each other and other formalities are followed that I've been guiding my clients through, we can go ahead and proceed with estate planning from beginning to end. My clients, new clients, and those who wish to update are able to go ahead from the beginning all the way to the end to finish their estate planning in the comfort of their home, basically in the context of anything from the original provision of information to me so that I can update their plan to the final signing of their documents.
Now, with respect to Chapman Law Group, are we technologically advanced enough where we can handle all of those platforms, whether somebody wants to set up a Zoom or a Blue Jeans or a FaceTime or any other kind of interconnection? Can we do that? Can you do that?
Yes, Ron, we have all those possibilities. In fact, I'm scheduled during the course of later this week to go ahead and do that again with clients. Clients will be over in Van Buren Township. I'll be here in Troy. I'll be able to handle things right there.
Well, two more questions that I have for you. One is, you're located in Troy. I'm located in Iron Mountain. Can I still hire you to prepare my trust?
Absolutely. Iron Mountain, Michigan, to a Troy, Michigan attorney, any attorney who's licensed in Michigan who has the knowledge, the expertise, the ability is what I would recommend. And yes, especially in this day and age, in the time of COVID-19, we have the ability to proceed with anything from beginning to end. And you can certainly hire me, and I'd be happy to help.
So here's my final question. So I've watched this video, I've listened, I get my spouse together, my kids, I say, we're going to do this. And then somebody says, but this stuff costs a lot. I mean, you're going to drop 5, 10, 15, 20, 100 grand to hire a super duper trust attorney to do this stuff. Is that true? Or are there affordable plans that you can put together for people that are very affordable for their situation?
Absolutely, Ron. Any individual, first of all, every individual should take the moment to look at what they have, to look at their loved ones, their spouses, their children, their brothers, sisters, parents, whoever it might be, and realize they need a plan. Now, there is no one plan fits all. It depends on the assets, it depends on the needs that that individual has, and it depends upon their means of being able to do it as well. So we could go from lesser to the whole works and beyond, and it depends on the individual and what he or she needs.
I use this example sometimes, and you probably heard me over the years. We've been together for many, many years. You can buy a Volkswagen for one price and a Ferrari for another price. And it's the same thing with estate plans and other kinds of things. You don't have to have the top of the end line with all the bells and whistles and all kinds of things. If your estate doesn't justify that, you can have a lower end and pay a much less reduced price or a much less price for that, correct?
That's absolutely right. All it comes down to is what does the individual need? And so long as it's done well, and I can tell you that I provide that kind of care. If the individual does not have much in terms of means, but needs a few things, including those powers of attorney and a will or other positioning of assets, I will help that individual. If that individual needs the whole Rolls-Royce complex and so forth, I am there and have the knowledge, the ability, the skills, and desire to help.
Well, Dave, this has been very interesting, and I hope viewers that you're very interested, and not just interested because this is interesting stuff, but interested enough to take some action, because everybody does. And while you may not feel the pain when you pass away or you get sick, your loved ones will. And if you care about them, this is the kind of thing that you need to step up and get it done. So Dave, any last comments you'd like to leave our viewers with before we sign off?
Sure, and that is, don't be one of the 50% who don't plan. Make sure you take that opportunity. I can tell you many people, unfortunately, their lives have slowed down by this COVID-19 time period. Take the opportunity now. Realize that you have some additional time, and now the governor has made the opportunity available to you that you can plan from the beginning to the end. Realize that this is a time for you to take advantage, carpe diem, if you will, for your own self, and realize I'm willing to help.
Great. Thank you very much, Dave.